All right, everybody, I'm going to start at the beginning. Good afternoon, everybody. My name is Leo Jacobs of Jacobs PC. We're a bankruptcy and commercial litigation law firm. Some of you that don't know about us, I'll be very quick and brief because we want to get into some of the Venus discussions we're going to have today with Samantha and Jacob Front, who works with us. I'm principally a bankruptcy and commercial litigator. We restructure about $5 billion of debt and equity in New York City and across the nation. And we've garnered a little bit of experience to share with all of you today about what office looks like and how to innovate it in the times of distress. So that's what the discussion is going to be about today. What's important to understand is that we are in an evolving market. Today, as many of you have seen, Donald Trump and his administration has won yet again, and that is going to have some consequences about what the market is going to look like in the very, very near future. We'll give you guys a very inside view of how to deal with a distressed asset. That is very, very important. It's very different when everything is good. It's very, very different when everything is bad. And we're going to have those discussions today. To the right of me, we have Samantha. She's part of our team. She's our ambassador. She works with us. She'll be asking some of the questions we have on our agenda today. And to my left, we have Jake Fryman, a prolific developer and a partner at Jacobs PC that works in the modification extension of the very issues that developers deal here with today. Principally three: how to modify their loans, how to get short payoffs, and how to deal with very, very difficult lenders. And let's not forget that while debtors are principally borrowers, in this time and in this age, lenders have also become debtors because they have numbers on their books that they cannot recycle and they don't know what to do with. And we'll discuss those things as well. Without further ado, I'm going to take my seat. I'm going to pass it to Samantha, and Samantha's going to ask some of the very questions we're all here to talk about. Thank you. Samantha, to you.
Yes. So I have the first question is, what are the tools to deal
for?
Jake.
come please? What are the tools and don'ts in dealing with the distress now?
So I think Samantha asked, what are the do's and don'ts of this?
Dealing with the distress now.
Yeah, so if you're an owner or a borrower, and when we talk about distress, we talk about two sides. We're talking about the distress that an existing owner borrower has to deal with, and we'll get to it a little later, what an opportunistic developer that wants to acquire a distressed asset for value add reposition. So we'll look at these differently. But with respect to a distressed borrower owner, the first thing I want to say is don't ever sign a pre-negotiation letter. And don't ever sign a forbearance agreement unless the circumstances that got you to the forbearance agreement justify you signing it. So why do I say this? So many lenders today won't even speak to you about a loan, let alone negotiate anything, unless you sign a pre-negotiation letter. And I can't tell you how many folks come into our office having signed a pre-negotiation letter, maybe reading it, maybe not reading it. Certainly if they read it, they didn't understand it, because no one in their right mind would sign what is typically a pre-negotiation letter, which says, Mr. Lender, I acknowledge that you are the lender. That's a problem, because if they didn't have a good assignment, you're not negating that amount. And then it goes on to say, and I give up all my rights as a borrower and as a guarantor. And I waive all claims which I may have had from the beginning of time until today. And I agree that I will not sue the bank, its shareholders, its officers, its directors, and anyone else in the world that we need to sue in order to get leverage on a lender. And so don't. If you're in a situation where a lender is asking you to sign a pre-negotiation letter, the first thing you do, pick up the phone. I hope you call us, but if you don't call us, call a very competent lawyer because you're on a bad track. What's the next thing you should do? You shouldn't sign up for a variance agreement. Same thing. It's just a worse stage of a pre-negotiation agreement. And now, if you're a borrower, what should you consider a reasonable workout, right? You know, so many people who have had their wealth built on residential commercial real estate are watching it deteriorate today, not because they have been bad managers, not because they're bad developers, but because we have market conditions that are so far beyond the reality of what they deal with. So even those who have solid, good, cash flowing assets that were purchased, say, prior to COVID, where you could buy these assets at a 3 or 4% capitalization rate, and today, with interest rates where they are, you can't value that at less than a 6.5% cap rate. So you have done nothing wrong, you've lost half your value. And even if your rents are going up, forget the office guys, there are no tenants, but if you've got a really solid residential building, the rents are increasing, and it's fully leased and stabilized. And you bought it in 2019, and you borrowed money on it then at 3%, so you leveraged the asset that was worth twice what it is today at 70%, and now you want to refinance it, given the interest rates, even though you have the cash flow, you can only borrow half that amount. So even on a good asset, you might have to write a check if you're going to keep the asset. So you have to really deal with these things. Now, what kind of deals have we been seeing in the market lately? It depends on the lender, and obviously lenders bid the buyers of the failed bank's signature bank calls, for example, others, the rent-regulated loans, the toxic stuff. That has a different path, and that path has greater flexibility, because the lenders bought those loans at 68 cents on the dollar, and second, because they know that they're toxic. So I'm going to sort of exclude out of my discussion those loans because one of the 3 or 4 institutions that acquired those, we generally can even do better than this. But what do I see in the world of workouts today? Generally, you can see a discounted payoff, but very rarely. It is the most desirable for a lender and the least likely you're going to get. But if you get a discounted payoff, the way you need to price it is based on existing in place loan constraints. So whatever market asset, if it's a residential asset, it's what Fannie Freddie does. If it's a commercial or an office asset or a retail asset, it's what the regional banks or CMBS market is doing. But you have to get the valuation of what is my LTV, what's my debt service coverage, what's the debt yield, and how should I value it on a capitalization rate, and what would my new interest rate be? With those 5 data points, you can calculate the maximum loan availability. And in many cases today, that'll be 60 or less % of your existing principal balance.
I have a question. No question. So, Jacob, if I understand this correctly, our topic here today is innovating office in distress. So, does innovation begin from coffee, from yoga, Pilates, how the office smells, or does it begin through the documents? Is innovation through the documents, right? Is that what you're saying?
Well, when you're working out, it's always the documents. When you're going to do a value-added deal, you got a lot more things to think about. I'm going to come back to some of the other ways.
Absolutely, absolutely. So I want to discuss what innovation actually means. And if you look at the title, Innovating Office in Distress, innovation begins not only through the exterior of the actual asset, but from the interior of the actual asset. And I mean that metaphorically. When you go to your attorneys, you're not asking them about whether you like to put in a new coffee machine, whether you'd like it to smell really, really nice. All of the things that you've been hearing in the outward manner about making something pretty, actually, all of it matters in the documents. And you have to have innovative counsel to make sure that your innovations, as they are through their exterior, actually come to pass. Otherwise, it is your lender that is going to be innovating office in distress. And that's something to think about. But while you're thinking about that, let's get to our second question.
Okay, so this question is for Leo. So if you can't work it out with the bank, what are other options?
Well, this is my favorite part of our discussion. You have to have sharp elbows. And what do I mean by that? Having sharp elbows doesn't mean you're throwing them around with your lender. It's being dangerous enough that your lender understands that if they do, in fact, enforce their rights, you will meet them with a formidable force. That is valuable in the times of Winston Churchill, not Chamberlain. Yeah, it's a funny story when Chamberlain was inviting Winston Churchill to have a discussion with him about taking over in this trying time in World War II, when Hitler was trying to take over. And Chamberlain and Winston Churchill sitting there and saying, Chamberlain says, well, you drink scotch, well, then you smoke cigars. Well, he's like, well, it's time to change the terrain. It's time to change the way we speak to our adversaries. And that is very, very important. If you don't speak to your adversaries in a way that they will understand you, because they're talking to you in a very different way. Now, you asked a very specific question, what if you can't work it out? Well, litigation is often seen as an adversarial process. And as one of the associates or partners in our firm says, Wayne Grewal, litigation is another form of negotiation. It's a ploy. It's a ploy that is set in place to create leverage. The creation of leverage in a discussion is what negotiation is in these times. It is not the times where your transactional counsel is telling you, don't worry, sign that guarantee, talk about that completion. No, not in these times. You're not going to sue your lawyer that didn't know about the asset dropping by, 50 or 60%. The value is in the strength of not only your counsel, but the way Jacob and I begin to negotiate from an offensive posture. And it is very true. The best defense is, in fact, today, the best offense. It's not going to be that way forever. It's not going to be that way forever. But today, do not listen, in my humble opinion, to the counsel that is Chamberlain counsel. You have to have a Winston Churchill behind your back, because Rialto, Maverick, and I'm going to put them all on the spot, and all these and other big lenders and private tiered lenders who are also becoming borrowers. They're also becoming borrowers. They're just not telling the borrowers that they are borrowers, but they have just as much to worry about with their investors in their board meetings. And they're having the same exact discussions that you all are having here today with your LPs and your GPs. Whoever is not talking about their issues with their LPs and their GPs, rest assured that you are creating more problems for yourself. Educate yourself about the way you traverse your negotiation style with your lender. That does not mean, however, Jake, that we have to be aggressive all the time. In fact, in Jacobs PC, we value lender relationships. Why? Because we know that we're going to meet our lender in another time, in another place. So innovating office in distress is innovating your discussions with your lender, being dangerous enough that they know you could do something, but being also dangerous enough knowing that you'll work with them. And that today is how you have a difference or make a difference in your negotiations with your lenders. So while you guys think about that, we'll go up to our third question.
So this question is for Jacob. Without naming names, can you give me an example of what a good workout looks like?
Yeah, great. So in light of what Leo said, and this is probably a great example. So we just finished a workout / loan modification on a large construction project that's about 80% complete.
What's the value?
The value of the project's got $250 million.
Okay.
The equity in this deal was about $150 million. There's a $92 million construction loan that went into default and matured after it went into default and is not enough given inflation to complete the project. Project means another $50 million and the lender's tapped out because there's $50,000 left to draw. So what did we do? We did exactly what Leo said. We managed to put the toughest litigation papers together and didn't file them. We shared it with the lender. And we explained to the lender that this is the document that will be filed if we cannot achieve a transaction. And I will tell you, it took us a month and a half, but the transaction ended up, and we do not guarantee these results for everyone, but we ended up with 18 million of accrued and unpaid interest and default interest waived. We got a subordination for up to 49.5 million of a new PACE loan. If you guys don't know what PACE loans are, they're now funded through the infrastructure program. They're energy based and they get taxed as an assessment against the real property as opposed to true debt. So we got 49 million of new debt coming in to finish the building. The 92 million accrues at the face rate for until December of 2025 with 0 payments. If the building is completed by December of 2025, all of the interest that accrued is waived and the payoff is $92 million. So we got a total of 30 million if this is paid on time, waived, and we got the right to put 49 million of new money in front of this existing lit.
I'd like to add something. When the client came to us saying, can you do me a big favor? I don't care about finishing the project. I don't care about anything about the project. I just care that you get me off of my guarantee and you allow me to continue my legacy. That's so important to understand the psychology, and I'll get up for this. It's important to understand the psychology, how a lender views a borrower. And from the lens of a lender, they're going to test the borrower's temperament. The temperament to make business decisions. How you rise and how you fall in business, whether it be real estate or otherwise, is in your business judgment. It's a legal concept that the judicial resources say. They say business judgment is when you can define what your decisions are for your success, and you will rise and fall with those decisions. You cannot make decisions when you are making emotional ones. You have to make rational ones. But rationality goes out the door when your equity goes down 75%. You're not thinking about your property anymore. You're not thinking about how to build or how to innovate office in distress. You're thinking about how to survive. And what our firm does really, really well is it places you back in control. It puts control back in your court. Having the power of saying no. The power of saying no to your lender, not to stonewall them, but to slow down the process. How would you achieve wings when you do? And that is the value of what happened with our client, and we were able to renegotiate it because we were able to first slow down the process. We were able to create short-term goals in a long-term format that ultimately achieved what Jacob achieved with the client. And you have to sit with the client. You have to endure the client's pain, both as a lender and as a borrower. I don't want to hear anyone telling me that it's all sunshine and rainbows in the real estate market. Yes, we're having a very big rally in the S&P and the Dow. The administration is in, everything is wonderful. But in the trenches, you have to know how to think rationally, not emotionally, and we help you in doing just that. Now, while you guys think about that, we have one more question, I see.
Yes. So this is for you. Leo, this is yours. How do you deal with the mezzanine loan UCC sale, and what are the best ways of dealing with that?
Okay. So UCC sales are not sales of real estate. It is sales of personal property. Now, everyone gets confused. They're like, Theo, I have a UCC sale. Oh my God, it pledged my interest. I gave everything away. I can't.
Also, you don't understand, when you get a mezzanine loan is a pledge of the equity interest in the entity that owns the real estate that you gave a mortgage to. that is secured by a UCC security interest, and that's what Leo's talking about. So some of you may not have said that. Sorry.
That's good. That's good. That's good. So you're in what's called a box. After you pledge your equity interests in the real estate, essentially, you're placed on the debt side where you're really over leveraged, and they've taken your equity interest. Now they have you for both ends.
So tell them how quickly they could get the equity interest versus how quickly they could foreclose.
You can foreclose very, very quickly in a UCC sale. But I'm going to tell you how to get out of it. The power of how you get out of it, again, comes back to how you interpret your lender. You have to have a discussion with your lender. If you hear you're a lawyer, please don't hire a transaction lawyer who drafted the documents for you. They do not know how to traverse that terrain. I don't care if you have Scattered Arps, Wallace Goschel, or the guy in Brooklyn or in New Jersey. Those individuals are not cut out to negotiate your loans. Not at this moment in time. You go to a confident law firm, and they will test the temperament of the lender in a UCC sale. Oftentimes, the lender will say, I am not listening to you. I am going to move forward with my sale. And I'll always mention what Jacob Fryman always says. Leo, make sure the client has, what should we make sure the client has? An appraisal of those equity interests. Because we're
At the date of sale, not the date after. It's correct. At the rate of sale. And the reason for that,
please, Jacob, please.
and this is, we practice primarily in the Northeast, and this is true at all the Northeast states and in most of the states, but not everybody has the same UCC or foreclosure laws. But the way it works is, everyone talks about deficiency judgments, right? You give a personal guarantee. You have a $50 million asset, you have a $30 million loan, it goes to foreclosure. The only person that shows up is the bank. And they bid $100,000 and they get the asset. And then they come and send you a letter. You owe us a deficiency of $29,900,000.
Plus, you have to finish the building.
So, if you have all the UCC says, and the foreclosure laws in most states say that if the value of the asset on the date of the sale, either of the UCC interest or of the foreclosure of the mortgage, is at or greater to the amount of the debt, irrespective of what it's sold for, doesn't matter that the lender paid $100,000. There is no deficiency, and in most states, you must bring a deficiency action, if at all, within 90 days of foreclosure.
Now, think of a borrower. I'll mention a very big one, Charles Cohen. He pledged about $577 million, and his $187 million guarantee. I think on Friday or Monday, his shares are going to be auctioned off, okay?
But when Leo says his shares, we don't just deal with NBs, right? You have an asset, you gave the bank a mortgage, and you say to yourself, I can't lose this asset until the bank forecloses. And in New York, it might take them 3 or 4 or 5 years, other places a year and a half, etc. But guess what? They can sell the equity interest in 10 days. The Supreme Court of the United States has ruled that 15 days notice is more than ample. And if they sell that, and where do they sell it? Not on the courthouse steps, in their office. And they invite you to show up. And no one comes, and then you get a letter that we sold your equity interest. Now the lender, or whoever bought it, owns the entity that owns the building that has the mortgage.
I'm talking about the mental state of a gentleman like a Charles Cohen that literally pledged all of his yachts, his big buildings. He doesn't know the law. He's surrounded by these individuals that created those documents. They're not researching. They're in aghast. They're saying, what do we do? There's an alarm bell. There's emotional thinking. There's no temperament. So one of the first things you have to do is you have to slow the process down. And you have to give the information that we are trying to give to you today, little bits of information that may change your temperament in business decision making. When you're innovating office in distress, you are really taking stock of the market turmoil, the consequences of that, and how you traverse that. You do not traverse that with emotional tie thinking. You have to get competent counsel that understands how to traverse that. Sorry, I don't want to be out of time. I want to open up for questions, right? Want to open up for questions.
Hopefully, I think we're out of time.
No. Okay.
Thank you, guys.
Thank you, everybody.
And if you